Welcome to Real Estate of Mind, a Farbman Group podcast. Welcome to another edition of Real Estate of Mind. I'm Andy Gutman with the Farbman Group, and today I have the honor and pleasure of introducing Steve Sallen, President and CEO of Maddin Hauser. And Steve is here today to talk to us about commercial mortgage-backed security loans and tell us a little bit about and enlighten us on that topic. Welcome, Steve.
Hi, Andy. How are you?
I'm great. Thanks for being on the show.
My pleasure.
Steve, I've had the honor and pleasure of knowing you and Maddin Hauser for many years. And I know I got indoctrinated with Mickey Maddin and his incredible legal career early on. I had the honor of working with him and the firm. And as a young buck coming up, I've always been impressed with your firm and all that you do. Over the last several years, I've really gotten to know you as you lead the way for Maddin Hauser into the future. And so I'm hoping for our public that doesn't necessarily, well, I know they all know you, but they don't know the real Steve Sallen and Maddin Hauser. Can you give the listening audience a little bit about both you and the firm?
Sure. Well, it was my honor to be mentored by Mark Hauser and Michael Maddin. This is the only firm I've ever worked for, Andy. I started with the firm in 1984, immediately upon graduating from law school. Back then, Maddin Hauser was known as a boutique real estate firm. Since then, we've grown and branched out into various areas. But you know, the center ring of the tree, if you will, is that real estate and transaction-oriented practice, and that's where I've spent and toiled my last 34 years of practice.
Wow. And you not only run the firm's day-to-day activities, but you are actively doing real estate deals on a regular basis.
Yeah, I don't make a living by managing a law firm, Andy, as you well know. That's not where the money is.
It's not it?
That's not it. I make the money by helping clients like you and the Farbmans and many others in navigating real estate.
Well, I know, at least from our perspective, we're grateful for the services you provide, and we're grateful for the expertise you give us on a regular basis.
Well,
so thank you for that.
Thank you. We appreciate the trust.
Steve, let's dive right in. I know our listeners are interested in finding out what a commercial mortgage-backed security loan is, also known as CMBS. Can you enlighten our audience?
Right. So, somewhere in the evil lurkings of a Wharton Business School graduate's mind, I suppose, was hatched the concept of a commercial mortgage loan, or literally dozens or hundreds of commercial mortgage loans that are pooled together and then sold as securities on Wall Street, or interests in those loans are pooled together and sold as securities on Wall Street. And what it provides to the real estate industry is another source to go to for real estate secured lines of credit or loans, usually purchase money financing or refinancing of commercial projects. It could be industrial, it could be multifamily, retail. It runs the gamut. And generally speaking, kind of middle to larger loans. These aren't really well suited to small, certainly not a $500,000 project, or even a $2.5 million project is not a great fit. So often it's in the $5 million category and up, and it can go way up. They can be quite large.
I think that's helpful in understanding that. And I think there was a great movie out that dealt a little bit with commercial mortgage-backed securities and how they're packaged and what happened in the Great Recession.
Yes.
Fantastic movie, by the way. We gotta point that out at the end of this.
Okay.
So knowing the size of deals and the types of deals that are made a part of the CMBS world, why would someone want to take out a loan under this methodology? What are the advantages of it?
Right. So there's a couple of real prime selling points for these kinds of loans. Probably first and foremost, they're non-recourse, in theory anyway.
And what does that mean for our people who might not understand recourse versus non-recourse?
That means for the project developer, let's say his name happens to be Andy Gutman.
Okay, nice
the
guy.
lender, nice guy, but he probably doesn't want to put his personal assets, his home, his cars, his dog, at risk. And so he doesn't want to sign a personal guarantee as you would with the traditional bank financing, where it's not just the company that is the debtor, but the principals involved will be asked to sign a personal guarantee. We call that personal recourse. And these kinds of loans are typically, well, they're always non-recourse to a point. And there are lots of exceptions, which I'm sure we'll get a chance to talk about in a few minutes. That is a prime selling point. Another prime selling point is their very competitive interest rates. They also have very good terms. Oftentimes they're a 10-year term, but with a 25 or a 30-year amortization. So the cash flow out the door helps to support the cash flow coming in the door, you know, at a rate where there's a profit to be made and returns to be given to the project and that project's investors.
Very nice. So those are some great advantages. I've also found that there's usually some ability to get some period of interest only at times on certain deals, which can be another advantage.
At times, yes. My personal experience is they're usually it's a short-term thing on some projects. Usually, well, although actually, I just recently saw one that had I think it had a 10-year component of interest only, but that was unusual, and that was actually handled by my partner Mark Hauser, who handles the most sophisticated projects that I've ever seen. The projects that I've worked on have typically not included that interest only component, but there is that sort of cash flow advantage of longer amortization, low interest rate, term of about 10 years is fairly typical.
Very nice. Those are some great advantages to it. Knowing some of the advantages, why would someone be, they sound fantastic, right? There's so many great components, non-recourse, long amortization periods, low interest rates. It sounds like just an exciting thing. What are some of the risks or downside associated with them?
Right. So how much time do we have?
We've got the full 15 hours. Okay. You just go at it.
Okay. So these are not loan packages for the faint of heart. Where to start in terms of where it becomes complicated? Let's talk about complication at the get-go when we start the loan. When you borrow a loan, you go to your bank, you're probably going to get a fairly standard set of documents. There's not a whole lot of negotiation back and forth, and the set of documents should take a competent, experienced attorney maybe an hour or 2 or 3 to go through and really analyze and understand and point out a top 10 list of comments they would like to address with the lender if it's possible. Oftentimes the document package for a CMBS loan can be literally hundreds of pages. Just the loan agreement itself. I've got one on my desk right now. We're on page 160 of the loan agreement.
Wow.
And then, of course, there is a mortgage. There's an assignment of rents and leases. There is a guarantee of the non-recourse carve-outs, which I'll put aside separately because we're going to talk about that. There is an environmental indemnification agreement and all kinds of other documentation that goes along with it. And the process is painstaking and often painful to inexperienced borrowers who aren't used to doing these kinds of projects. And if they aren't used to doing these kinds of projects, they can really, by the time they get to the closing table, their hair may have all been pulled out.
It's very true. So let me ask you this question while we're talking about it. And maybe it's time we move into the issues associated with the non-recourse carve-outs, if you will. Talk to me about what those might be and how that could affect the fact that this is something, it's a non-recourse loan, but could become recourse with some of these carve-outs.
Right. So I said before, they're non-recourse, sort of. So first of all, they are usually sold along the lines of, well, they're recourse for certain bad boy acts, and that's how the loan brokers like to sell them and how the lenders like to refer to them, making it sound as though you know, if you aren't a bad person and you don't try to defraud the lender, then you're never going to have any risk of recourse. And that sounds really good until you dive into the complicated language that is the non-recourse carve-out language. And it turns out there is recourse, and some of it is not all that cut and dry. So let's just take an example of what's cut and dry. What's cut and dry would be security deposits. Let's say I have a multifamily project, an apartment building. I'm holding on to, you know, literally hundreds of security deposits for apartments.
Right.
And if there is a foreclosure on account of a default, where is that money? Where does it go? And if the lender doesn't get it in the course of foreclosure, then whoever it is that guarantor of those carve-outs is going to be personally responsible to make sure that those dollars find their way into the lender's lap. Very important point. Fraud or misrepresentation in procuring the loan, that's pretty easy. Gross negligence or willful misconduct in the conduct of the borrower's operations during the term of the loan. Commission of a crime resulting in forfeiture of the property, because we know there are certain federal drug laws where the federal government can literally seize real estate as a penalty for engaging in illegal felonious conduct. Failure to properly or to properly apply the proceeds of insurance. If there's a casualty event, you know, the borrower decides I'm going to put the proceeds of insurance in my pocket instead of rebuilding the building, the lender is going to chase you down, hunt you down, and get those dollars back for sure.
And those are truly, you know, bad boy provisions. They're things that you shouldn't be doing. You know, security deposits should be in an account that you separate out and make sure you have those on hand.
Right.
So that makes sense, right?
That makes sense, and it's hard to argue with that.
Right.
But the language usually goes a little bit further depending on the lender. Some are a little more onerous, some are a little bit less onerous, but they're all onerous.
Right.
Okay, let's get that straight. But here, so a borrower has to be, in the CMBS world, what's called an SPE, or a special purpose entity, meaning it can only own one thing. It needs to be newly formed for purposes of buying the asset or owning the asset that we're talking about. And there is literally pages of covenants that the borrower is supposed to honor so as not to not be an SPE, or single purpose entity. And if there is a unintentional breach of one of those covenants, there can be what's called springing recourse, which is not just am I liable for the damage, which, like in the security deposit case, you're liable to give back the security deposits, but when you have a springing recourse obligation, the entire loan all of a sudden springs to life as a full recourse obligation to that guarantor.
Right.
$25 million loan, $25 million liability to Mr. Smith, as opposed to just, you know, XYZ development company.
Right, and that is certainly not a bad boy issue where you've done something that is intentionally wrong, or there's no misdeed per se.
Another example is the environmental covenants. Basically, a borrower and the guarantor is going to be responsible for anything that happens on the property that is bad from an environmental standpoint. So, for example, an industrial building or an industrial complex that has one of these loans in place, there can very easily be something that goes wrong. There's a release, a spill of some kind. Well, in a catastrophic situation, there could be, as you know, in the environmental world and in the industrial world, there can be hundreds of thousands or millions of dollars of liability if there's contamination of water or the land, so on and so forth. Every penny of environmental liability that a lender might suffer on account of this, or diminution in value of the building if they go to foreclose and sell and they can't recover because the property value has been impaired, all of that is going to be recourse to our friendly guarantor of the covenants.
Yeah.
Or of the carve-outs, excuse me. I've also seen it used where as a bridge to get over certain things. So, for example, a few months ago, I closed a loan where we had a zoning issue where the city would not agree or give a letter basically saying that in the event of a casualty, that the project could be rebuilt to the same specifications, basically rentable square feet, right?
Right.
They wouldn't agree to that because the property had been grandfathered. It was originally developed many, many, many years ago, and new, zoning and setback requirements would have prevented reconstruction of the building to that full size if that came to pass. So instead of not making the loan, what they did was in the carve-out, they carved out any liability that might arise by virtue of the fact that the property cannot be rebuilt to the same size meaning money, because dollars per square foot in and therefore dollars out to pay the lender. So if they're affected in any way, that became a carve out. And I've seen that more often recently, where the carve out is being used, actually I would say in a fairly creative and constructive way.
Yeah.
But I don't think that, certainly the owner isn't a bad boy if the project, suffers a tornado or burns down, and because of no fault of the borrower, the city will not allow reconstruction to that same size or standard.
So, I mean, if you're going to utilize this tool to finance your projects, you really need to go with your eyes wide open, knowing that even though it's sold as a non-recourse loan, there are a lot of factors that could quickly turn this into recourse that are not truly just you doing something intentionally wrong or wrong in particular.
That's right. And you really need to have someone in your camp, a lawyer who is familiar with these kinds of loans, who understands what these covenants are and what can be negotiated and what can't. Some of it can be negotiated, some of it can't. But at the end of the day, if you don't know what you're signing, believe me, you're signing a nightmare. And maybe even signing away your life if you're not, really paying attention to the details on this stuff.
Yeah, you clearly could never do one of these loans. Not that we ever recommend doing a loan without legal representation, but there's absolutely no way a layman could do a loan like this, period, without legal representation.
Right, and in fact, one of the reasons is, aside from just being in over their head, not to sound condescending, but the lender is going to require an opinion of counsel letter.
Right.
And the opinion of counsel letter is going to talk to the entity being validly formed and existing and so on and so forth, but also to the enforceability of the loan documents. And in a typical bank loan, there's no opinion of counsel necessary.
Right.
But here, there is always going to be the requirement of an opinion of counsel, and sometimes a non-consolidation opinion, which is a whole nother complex kettle of fish that probably adds, a 5-figure dollar amount to the attorney fee bill that we see in, loans at the $20 million and up size.
Yeah, and that's another piece to this that we probably should mention. The cost to even transact this type of loan is significantly higher than a typical bank loan.
Right.
Your
and that's
fees
kind of what I
costs.
was driving at when I was saying that there's a level of complexity at the very beginning. I was talking about a 168-page loan agreement. It's going to cost more. You're going to be budgeting more in attorney's fees for this kind of loan than you did when you went to, Bank of America or Comerica Bank and, financed a 5,000 square foot addition on your warehouse.
Right. No, significantly so. So knowing the complexity of this, let's talk a little bit about the vehicles that are out there and how they stack up against this. You've got a few other vehicles that people can use to finance their projects that aren't CMBS loans. Do you want to speak briefly about what those are and some of the ways that they might have pros and cons versus a CMBS loan?
Well, there's traditional bank financing, and we've had good luck recently with community banks. Small regional and community banks where they've got money to lend and fairly aggressive terms, but there's personal recourse involved, and oftentimes tying up all of a client's particular entities. If he's got 3 or 4 businesses, then chances are all the affiliated businesses or related businesses and people involved are going to be signing personal guarantees or full recourse. So it kind of becomes a little bit of a house of cards. This one thing fails, it could bring down the whole thing, right?
Sure.
There are larger banks which begin to look more like the life companies. So there are life companies,
Right.
And larger banks where there's a more sophisticated kind of attention to detail, including guarantees that start to look like these recourse carve-out guarantees I was talking about with CMBS. That has bled over into the life company world and even into the larger bank world. I've seen very similar provisions. Aha! I know where that provision came from. That came from the CMBS world.
That's all very true, and it's interesting. The other piece to it that, from a borrower's perspective, that I want to throw in there is a significant thing you have to think about. When you do a CMBS loan, it then shifts from that lender, once it's sold, to a servicer type of relationship. Yeah. And the servicer or sub-servicer or special servicers, all part of a longer topic we could do over the course of another session.
Yes.
Really focus on making it very difficult. If anything out of the ordinary arises, it becomes a long, arduous process to get through how that gets handled. Whereas in a banking or other relationship type of borrowing, you have your relationship manager with some, at least, flexibility, ability to speak to you face to face and pivot and make those decisions in a rapid time frame, which I think sometimes gets overlooked in the
It does get overlooked. First, I think I heard you invite me back for a second talk.
Absolutely.
I'm sort of fleshing out some of this stuff. But the relationship issue here, especially for the uninitiated borrower, it's shocking, or they are shocked to learn that common sense will not prevail.
Right.
For example, after the fact, you've closed your CMBS loan, and a year later, you have an outlot on your property, and you want to sell that outlot or lease that outlot. Let's say it's a small retail shopping center, and you want to put a Starbucks coffee in the outlot, or you want to sell it off. Any of those permutations, you're going to go talk to your lender. Well, in this case, in the CMBS world, there's nobody to talk to. There is a servicer who only cares about one thing, Andy, and that's getting their monthly check. Everything else, they're going to charge you fees up front, and then they're going to probably say no, or they're going to drive you crazy, notwithstanding the fact that this lease may enhance the value of the property, it will advance the value of the collateral, it will add additional cash flow to the borrower's bottom line. They don't care. Right. They don't want to deal with it. They don't want to hear about it.
Yeah. Well, it's not the basis of their loan, right?
It's not the basis of their loan. And it's not what they promised to their investors when those Wall Street securities were packaged and sold.
Absolutely. So it does become a little tougher to do anything creative on your property that could indeed enhance the value.
And what I tell people is plan up front. If you want to do a CMBS loan, you better start thinking, do I have an outlot or a potential outlot?
Yeah.
And maybe, like I did about 6 months ago with a client, we carved that out of the deal.
Right.
We took it out up front. And it delayed our closing a little bit while the lender sort of understood what it was we were trying to do. And once that was done, it was no longer part of the collateral. And it was owned by we transferred the land into a different entity, and we're free to do whatever we want now because it's no longer part of that CMBS loan.
And that's a little bit, not only does the borrower have to think about that, but it's something that having a sharp legal representation, they're going to think about those things as well when they're reviewing the survey and other aspects of it. Having the right person in your corner, your experience knowing that this occurs, and knowing the difficulty later on of transferring that out comes in incredibly handy.
Yeah, and just the experience of knowing that common sense will not prevail.
Absolutely. But I love this topic. I think it's a really complex topic. I did invite you back for another round, and I do think people are absolutely going to enjoy this and learn a lot. And so at some point in here, you mentioned that it's important to have legal representation. And I'm wondering if you know of anyone that might be good to contact if someone needs legal representation for their loans? Is there anyone you can think of that would be a fantastic person?
Well, Andy, I'm not one to toot my own horn, but
Okay.
Your friends and listeners can always contact me, and if I can't help them, I'll see if I can find somebody that can.
All right. So contacting Steve Sallen and Maddin Hauser, and how do they get a hold of you, Steve, if they want to find you?
Well, they can call you for the phone number, or they can write down 248-827-1861.
Great. All right. And you also have a website that they can go to for more information?
Yeah, maddinhauser.com.
That's pretty easy.
That's pretty easy.
maddinhauser.com. So I really appreciate you taking the time to enlighten our listeners, tell them what's going on in the world of borrowing and lending. And we are definitely going to do another one of these when your really busy schedule permits, when you're not helping people with their loans. And really appreciate it. On behalf of Maddin Hauser and the Farbman Group, I'd like to thank you for joining us today for another episode of Real Estate of Mind. Join us next time for another wonderful edition of Real Estate of Mind, a Farbman Group podcast.